2009, PLF has some great victories supporting freedom. In property rights, for example, in Liu versus International Boundary Commission, we eventually persuaded the commission to back off and to allow a couple to have a small garden wall on their property near the international boundary. Previously, they had said this is a security threat, and when members of the commission actually came out and looked at the wall, they were standing on it and said, "What's the problem? Where's this wall?" Clearly a case where the freedoms of the owners to have a little garden wall on their property was unfairly taken away. In Citizens Alliance for Property Rights in King County, we succeeded in having a requirement where up to 65% of people's rural property could be taken away and put into a permanent no-build zone for any kind of permit they required. This is against Washington state law, and the King County, which is a county where Seattle is, was appropriately reprimanded by the court. And in Severance versus the Land Commission in Texas, we succeeded in convincing the Federal Fifth Circuit Court of Appeal to consider whether or not a regulation and a restriction on the use of beachfront property might violate the Fourth Amendment's prohibition against unreasonable seizures. That case is now going before the Texas Supreme Court. We have defended the rights of liberty and the freedom of contract and the freedom to have a business. In Sweet versus Myers, we eventually succeeded in having a law overturned where if a person wanted to enter into a moving company, in this case some college students wanted to make some money by having a little moving company, they were told they could only do so with permission of their competitors. Obviously, competitors don't want competition, and the rule was held to be simply flat out wrong, and the legislature in Oregon eventually overturned that rule. We've had some great environmental victories. In Summers versus Earth Island Institute, the Supreme Court said that individuals who did not really have any interest in the forest where they had filed protests and filed a lawsuit could not proceed with the lawsuit because they had no interest in the outcome of that lawsuit. In Core, Alaska, we succeeded in helping convince the Supreme Court with an amicus brief that a mining company could proceed by putting its tailings in an environmentally sensitive way into a lake and subject to certain restrictions and effluent regulations. But what the environmentalists wanted to do was simply have the restrictions so onerous that the mine could not operate at all. The Supreme Court struck that down. And lastly, we've had some great victories in the area of discrimination, where the U.S. Supreme Court in Ricky versus DiFestano, in a well-known case of We Are Amicus, said that the city of New Haven could not throw out tests simply because not enough minority firefighters passed that test. And lastly, in Rothley Development versus the United States, we were participating and we received a good decision where the Department of Defense could not use racial quotas in its contracting. It was asking for contracts with racial quotas. We submitted a friend of the court brief, and the Circuit Court agreed with us that that was unconstitutional. Bottom line is that with our fights in the courts day in and day out, we are making progress for freedom. It's a particularly difficult and trying time right now, but we think that all we can do and the best we can do is go to court and win.